Hello, everyone. Hello, and welcome back. Thank you for staying with me as we journey through the model rules of professional conduct here in our exploration and preparation for the multi-state professional responsibility exam. You remember me, I'm Patrick John McGinley. I'm your friendly neighborhood bar grievance defense counsel. Today's class is scheduled to start right about now, but of course, we all need a break from time to time. And you'll forgive me, please, but I need about a 12-minute break here myself. So if you're watching this video other than live, what you'll want to do at this point is to go to the very bottom of your screen over here. And as you hover the mouse, you can fast forward the film and you can skip approximately 12 minutes and 53 seconds because that is approximately the length of the break I'm about to take. After that, we'll take a deeper dive into the multi-state professional responsibility exams, requirements of knowing the model rules of professional conduct. And if you're watching me live, I apologize for taking the break so early. And I'll see you back at 7:45 p.m. as my very handy and professional sign here says. I'm back. Guess who's back? Back again. All right, get this set. You want to see all of McGinley? Of course, I'm McGinley. You know, that's McGinley. All right. Got to shuffle the papers because that makes you feel like you're prepared, right? Yeah. Okay. Hello, everyone. You remember me? I'm Patrick McGinley, your friendly neighborhood bar grievance defense attorney. Thank you for studying the Model Rules of Professional Conduct with me. Thank you for taking this deep dive with me into professional responsibility. We're getting ready for the multi-state professional responsibility exam. And in so doing, we're looking at various model rules of professional conduct. Today's theme is Officer of the Court. And admittedly, I'm stretching today's theme a little bit. Some of the rules that we're looking at are a bit hard to put together into one theme. But as we move from lesson to lesson, I want each lesson to have a theme. And today's theme is a bit of a stretch, but still does tie these particular rules together. So what? Officer of the court, by which I mean that beautiful phrase that our profession has perpetuated over the years. We have decided that we're more than just the zealous advocates of our clients, which of course we are and we should be. But more than that, we are also officers of the court, by which we acknowledge as lawyers our proper role in government. We are, in no small part, the judicial system. We are that branch of government known as the judiciary, or at least we have an important role to play in making that particular branch of government function and work well and work as a service to our fellow Americans. So in no small way, we are public servants insofar as we are officers of the court. And with that theme, I'm drawing together four separate rules today from 3 separate chapters of the Model Rules of Professional Conduct. You remember chapter 1, that talks about the lawyer-client relationship. And from chapter 1, we're going to be looking at rule 1.11. 1.11 talks specifically about special conflicts of interest of former and current government officers and employees. So we're going to be talking about judges. We're going to be talking about government officials. We're going to be talking about agency employees and agency heads. We're going to be talking about those who had access to government and government information and now are here in the private sector. Obviously, there are a lot of U.S. code, state code, other rules and regulations within the statutes. We specifically will be looking at the rules and regulations in the Model Rules of Professional Conduct. So our deep dive is not so deep if you consider a deep dive to go beyond professional responsibility, but we will be taking a deep dive from the perspective of those who are studying professional responsibility. Also, we're going to take a look in chapter 1, our client-lawyer relationship chapter, at Model Rule 1.15, which talks about the safeguarding of property. Within that discussion comes our obligations as trustees, if you will, of the public trust, insofar as a lawyer can and often does have a trust account. What are the responsibilities of a lawyer when it comes to having and maintaining a trust account? How do we balance the lawyer's own financial interests and the interests of the public? How do we balance the fiduciary duty of the lawyer who may be holding in trust funds that were obtained from his or her own client, or perhaps duties to the public for funds that were obtained either on behalf of his or her own client or despite his or her own client? Trust accounts are a means by which many a lawyer has found herself or himself subject to discipline. It's certainly worth studying, and it will fall under our theme tonight of Officer of the Court. Those are the two rules we'll look at from Chapter 1. From Chapter 3, we'll be looking at Rule 3.5. Here we talk about impartiality and decorum of the court or the tribunal. As an officer of the court, we have certain duties when it comes to impartiality and decorum. As an advocate, we have less duties of impartiality. But even as an advocate arguing on behalf of our clients, we have duties of decorum. We're going to look at what Model Rule 3.5 imposes upon us lawyers when it comes to those duties. Last but not least, we'll be revisiting that ever-present Rule 8.4. You remember Chapter 8. Chapter 8 talks about maintaining the integrity of our profession, and 8.4 in no small way is that catch-all, that very broad, almost void for vagueness, you might argue, very broad Rule 8.4 that ties in so much behavior and makes it subject to rules of professionalism, even behavior that might be outside a courtroom. We'll be taking another look yet again at Rule 8.4 as it applies to tonight's theme, Officer of the Court. So with that roadmap ahead of us, let's begin at the beginning. That is going to be Model Rule 1.11 of the Model Rules of Professional Conduct. Rule 1.11 tells us from the title that it's discussing conflicts of interest. Conflicts of interest is something that we are going to return to again and again. And indeed, there will be lectures dedicated to nothing but conflicts of interest because it is so ripe for testing in the MPRE, and it is ripe for pitfalls in actual practice. So tonight we will begin, but we will not exhaust the topic of conflicts of interest. Tonight, our look at conflicts of interest is limited to special conflicts of interest for former and current government officers and employees. Now, is it permissible, generally speaking, to have been an officer of government and then to leave public life and enter into private service and become private counsel dealing with the agency with which you used to work? Now, that's a loaded question because, as I mentioned as we started this lecture, that question can only be answered in full by taking an exhaustive look at all the particular rules and regulations of that former agency, by looking closely at the U.S. Code, and by looking closely at state statutes, which are all implicated by the move from public servant to private practice, especially if that private practice is going to involve dealing with the agency or government entity for which you used to be the spokeswoman or spokesman or attorney or employee of. So I'm not giving you a complete answer to that question. Instead, since our goal is to take a deep dive of the Model Rules of Professional Conduct as needed for the Multi-State Professional Responsibility exam, I'm going to focus only on one particular source of answer of that question, and that is Rule 1.11 of the Model Rules of Professional Conduct. But my caveat is well meant and well to do, and an important thing to point out is what I'm trying to say, because in real life, to answer this question, you're going to need to know more than you need to know for the MPRE. Tonight, let's focus on what we need to know for the MPRE, and that is Model Rule 1.11. Now, if a lawyer participated personally and substantially in a matter in which the lawyer now is being called upon to participate in private practice, that is not allowed. You can't, as a former public official, represent a client in connection with a matter where you personally and substantially participated as a public official. That is defined in Model Rule 1.11 as an impermissible conflict of interest. Is there a way to avoid being subject to discipline? And the answer is yes, if we follow the one and only exception that exists in Rule 1.11. The exception is the following: the appropriate government agency has to agree. If that agreement is made with informed consent and it is made in writing by the agency's appropriate and fully authorized individual, then and only then can you assume the representation in private practice despite the rule saying that it's a conflict of interest. When must you get this waiver? At the commencement of the representation, right away. How do you get this waiver? By providing informed consent to the agency. The onus is upon you to make sure the agency knows everything it needs to know so that that consent can fairly be called informed consent. And it's not enough to get a handshake. It's not enough to get a phone call. It must be in writing from an authorized representative who's duly authorized and had the power to make that writing, to make that waiver with informed consent. So it's a difficult thing to do indeed. Difficult under this rule, but even more difficult in reality, because that agency has its procedures, it has its rules and regulations. Indeed, it has its own rules of ethics, which go beyond what we're covering today as we prepare for the MPRE and we take our deeper dive into the model rules. But when it comes to a model rule answer, is that a conflict of interest? Yes. Can it be waived? Qualified? Yes. Qualified by all those requirements that we just went over. So that is a conflict of interest. And that is the very detailed and limited way in which the conflict can be waived, at least insofar as the model rules are concerned. And after that, got to deal with the agency ethics rules, the United States Code, the U.S. Code of Federal Regulations, state statutes, etc., ad nauseum. Now, what is a matter? Because this Rule 1.11 applies to any matter in which you were personally involved when you worked for government. Is matter limited to just a lawsuit? Are we talking just about lawsuits here? No. Matter has a broader definition. It's any judicial proceeding, certainly, or any other proceeding, application, request for a ruling, or other determination. Also, any contract. So maybe you're doing not litigation, but contract work for the government. Now you have private clients who wish to get a contract or wish to have rights under that contract or provide services under that contract. That meets the definition of matter. Any controversy. Maybe you didn't get in front of a judge or tribunal. Maybe you weren't looking for a ruling while in government. Maybe it was just pre-suit, or maybe it was just hypothetical, theoretical, or latent while you were working in government. But it was a controversy. So that meets the definition of matter and means that you have a conflict of interest under Rule 1.11. Any investigation. So you were involved with the investigation in government, you left government. I'm sure those who are under investigation as part of that investigation will be very interested in having you as their lawyer. But you, my friend, have a conflict of interest. maybe you'll get it waived by following all those detailed and crazy requirements in Rule 1.11 plus the U.S. Code plus the Code of Federal Regulations plus any applicable state statutes plus the rules of ethics of that particular agency. Or maybe not. What about an accusation? Yes, that meets the definition of matter. Any other particular matter involving a specific party or party. That meets the Rule 1.11 definition of matter to cause a conflict of interest. But here's the ultimate catch-all. Here's where Rule 1.11 pulls in other rules. Model Rule 1.11, subsection E, subsection 2, includes within the definition of matter any other matter. Don't you love when you define a word using that word? That's what they did. Matter means all those things we talked about. Also, matter means any other matter covered by the conflict of interest rules of the appropriate government agency. So, if you violate the internal ethics rules of that agency, or you violate the U.S. Code, or you violate the Code of Federal Regulations, or you violate the internal operations procedure of that agency, or you violate an applicable state statute, that becomes a violation of Model Rule 1.11 under this definition of matter that you find in 111 subsection E subsection 2. So, is it easy to go from public to private practice? I think it'd be fair to say no, especially insofar as it involves doing the same kind of thing in private practice that you were doing in public practice. Maybe as time goes on, it becomes easier. And why would I say that? Well, perhaps there's less likelihood of your personal involvement in the matter as time goes on. Maybe the agency takes on new matters and clients value your expertise as having been a former employee or attorney of that agency, even though you weren't personally involved with that particular matter. Because remember, we're talking about when the lawyer participates personally and substantially. That's what causes the conflict of interest. So eventually, as those contracts expire and matters resolve and disputes and investigations wrap up, eventually you become someone who wasn't personally involved with this potential new private client's particular matter with the agency, but you bring to the table that expertise of having been on the inside and knowing how that agency works. That can be a valuable thing to a potential new client. But that also brings us to a requirement that you find both under Rule 1.15 and, of course, under that catch-all of Rule 8.4. Whether you cite the source of this particular rule as 1.15 or Rule 8.4, nevertheless, the following is true. You can't imply to a client or potential client that you can influence a government agency. I'm sure those who either aren't aware of their ethical obligations or don't care about them would find it very tempting to sign up new clients by implying, I used to work for that agency. They're all my friends over there. I know how to pull strings. I know how to get favors. They owe me a favor. I can get results others can't because they're my friends and they owe me and I can pull strings. These kinds of promises, true or not, are a violation of either Rule 1.15 or Rule 8.4 or both. They're impermissible. It's not permissible to state or imply that you can influence or have improper influence over any aspect of the judicial system or a government agency. Now, generally speaking, one could argue it's true that if you have a license to practice law and experience with this particular area of the law, that can give your client an edge. That's okay to say, but it's something anyone can say. When it comes to advertising, it's got to be truthful. It can't be misleading. And it's got to pass the smell test insofar as it can't be stated in such a way as to mislead. If it's true about everyone, you can present it that way. Like all lawyers, I have knowledge of the legal system. But to state or imply that you have the ability to exert an improper influence over an agency or a judge or a hearing officer or a justice or a tribunal or a witness or a police officer or any other part of the legal system, that is a clear violation of both Rule 1.15 and Rule 8.4 of the Model Rules of Professional Conduct. So that is not allowed. Let's turn now to that topic of topics. Rule 1.15, safekeeping property. Rule 1.15, safekeeping property, speaks in specific terms about trust accounts. What is a trust account? A trust account, stated most simply, is a separate bank account containing other people's money. That's a trust account. The legal profession is not the only profession that might maintain a trust account. For example, real estate closings and title companies might be involved with what they may call an escrow account, another type of trust account. You too might be involved with the trust account. Likewise, as part of an estate plan, there may be a springing trust, or perhaps even before the passing, someone might create either a revocable or irrevocable trust. Any of those might hold assets. Those too would fairly be called a trust account. The model rules cover those, but the model rules focus upon attorney trust accounts. And even attorney trust accounts come in at least two different types. First is called either the IOTA or IOLTA trust account. Called IOTA, if you consider the abbreviation to be IOTA, interest on trust accounts, or called IOLTA, if you consider the abbreviation to be interest on lawyer trust accounts. This IOTA or IOLTA account is one type of a lawyer trust account. The other is simply a trust account. The difference between simply a trust account and either an IOTA or an IOLTA trust account is the payment of interest. For the IOTA or IOLTA account, and for the sake of not making this lecture sound like an alphabet soup of abbreviations, from now on I'll just call it an IOTA account. But as you know, it could be called IOLTA. The IOTA account is an interest-bearing and interest-earning account. But that interest does not go to the attorney, nor does it go to the client or other individual whose money is in the account. The money from the IOTA account goes to the state bar. The bar uses that money in the public interest. For example, here in the state of Florida, we have a group that spends that money. Some of it is apolitical. Some of it, unfortunately, is political. But all of it is at least intended to be in the public interest. Any other type of account may or may not earn interest, and the lawyer must enter into a written agreement with the client as to where that interest goes. So if the money that the lawyer is holding is not held in the IOTA account, but instead is held in just a trust account, then there should be some clarity between the lawyer and the client as to where that money is going. It's the lawyer's obligation to reach that clarity. Now, why the two accounts? Well, the model rules state, and state bar rules perpetuate this requirement, that money held in the short term must be held in the IOTA account. Money which is not held in the short term can be held in just an ordinary trust account. Now think about that. What if it's a large amount? Thousands, millions, tens of millions. And your client says, hey, I know we've got a settlement with the insurance company for $20 million, and you're only going to have it for the 30 days it takes to resolve all my liens and pay me the rest. But it's going to earn some interest over those 30 days. I want the money. I want the interest that is earned, even though you might just have it for 20 or 25 or maximum 30 days. Unfortunately for the client, the rules of professionalism require that money to go into the IOTA account because it's kept for short term, and forbid that money from going into just a trust account where either you or the client or both of you might share in the revenue of the interest. Instead, because it's short-term money, it's got to go into IOTA, and the interest is kept by the state. Now, did you see what just happened? The state took someone's property. Ah, McGinley, you say to me. I studied constitutional law. I know that if the state takes property, that's a violation of a constitutional right. That's a taking. And takings require fair compensation, just compensation, adequate compensation. However, a ruling from the United States Supreme Court holds that although that meets the definition of a taking, the requirement that the short-term funds stay in the IOTA account and that the interests go to the public through the state bar. SCOTUS, the Supreme Court of the United States, acknowledges that meets the definition of a taking, but says it is not a violation of anyone's constitutional right to keep that interest, spend it for the public benefit, and not compensate the individuals from whom it was taken. This is a holding of the Supreme Court of the United States. And due to that holding, just about every jurisdiction has enacted these IOTA or IOLTA trust account requirements, Florida included. So, what money goes into a trust account? That's often tested on the MPRE, and it's something you've got to know if you operate a trust account in private practice. Money to which you have not earned ownership of must go into and stay in a trust account until you earn ownership of it. What am I talking about there? Well, sometimes when you sign up a client, you ask for some money up front to secure your payment of your future fees. Now, this is common in some areas of the law and uncommon in others. For example, I have friends who are criminal law defense attorneys. It's quite common for them to charge a flat fee, all of which is due and payable either upfront or early in the representation in a short amount of time and with very few payments. For those lawyers, they may or may not be using a trust account, depending upon the agreement they reach with their client. You must reach an agreement with your client about any funds that you receive from your client. You must reach an agreement as to whether or not you have earned those funds. So, for a lawyer who's going to bill by the hour, that lawyer hasn't earned anything until that lawyer works an hour. And even then, that lawyer has only earned 1 hour worth of fees. But you might not like the risk. You might not want to sign up a client just on a handshake, hoping someday they might pay you for all the hours you're about to put into their case. This can be particularly true if you make a notice of appearance in front of a tribunal that has the authority and discretion to decide whether or not you're allowed to withdraw. What I'm saying is, depending on the rules of the tribunal, If you make a notice of appearance, you might be in there for the long run, whether you like it or not. So for that reason and others, a lot of lawyers, before they'll sign up a new client, they want some money up front. They might call it a retainer. They might not. But they have to reach an agreement as to whether or not that money they've received is earned when received. Now, under the model rules, they use the phrase retainer, but they use it with specificity. Under the model rules, retainer refers to money that is paid not for future work to be done, but for the right to have that lawyer do the future work when requested. It's sort of like paying the lawyer to stay on standby. And it's very much like assuring the fact that you know you're going to get that lawyer to do your work when you need her or him. Under the model rules, that's the definition of a retainer. Under the model rules, a retainer is money paid to a lawyer, not as security, but as a payment in return for that lawyer being on standby and ready to do future work for which he or she will be paid in the future. That's the technical definition of retainer used in the model rules. In the vernacular and everyday speech, as you talk to lawyers, they can get loosey-goosey with the term retainer. They might use it to mean any kind of money that they're paid, such as what they should be calling a security deposit. A security deposit is money paid now to secure the payment of future work. With those definitions in mind, what's the difference between a retainer on the one hand and a security deposit on the other? Well, first and foremost, the retainer has been earned when received, assuming you agree to be on retainer. You agree to be there and do the future work and not decline it from that particular client because they paid the retainer and get paid for that future work in the future. So the retainer, by definition, if you're using the model rule definition, the retainer by definition is earned when received, and the retainer need not be in the trust account. What about the security deposit? The security deposit is money paid now to make sure the lawyer gets paid later. Think about this. Say you decide to sign up a client. You're going to help her or him, or if it's an entity, it, with its legal problem. And that's going to take 10, 20, 30 hours a month for, 4, 5, 6 months, 8 months, 9 months. How do you know they won't stiff you on the bill? How do you know when you send the monthly bills that they'll be paid promptly? You don't. So you can ask for a security deposit. That goes in the trust account. You haven't earned it. Then you might send out the bills. And you might get payment for the bill, payment in full. And again, the security deposit stays in the trust account because you haven't earned it. Then next month you send out the bill. It gets paid again. Again, got to leave that security deposit behind. You haven't earned it. But then you start sending out bills and they don't get paid. You talk to the client, they're not able to pay. You point out the breach of contract in your contract for hire when they hired you. And they acknowledge, yes, you're right. I promised to pay. Yes, you're right. You're owed that money. Yes, you're right. Your invoice is fair. Yes, you're right. I'm not disputing the amount of your fee. I just don't have the money. I just can't afford it. At that point, you can go into your lawyer trust account and withdraw funds from the security deposit. Do you get all of it? No, you get the amount you've earned. What's the amount you've earned? That can be an easy question to answer under the hypothetical that I gave a few moments ago. That hypothetical was the client admitted they owed the money. The client admitted they were behind on the bill. The client did not dispute the amount or the propriety of your bill. The client just was apologetic for not having the money and had an inability to pay. Under those facts, The amount you've earned is the amount of your invoice. But let's make the facts a little bit harder, shall we? What if the client admits, you did some work. I don't know if it's all the work I see on this ridiculously high invoice of yours, but you did some work. I should pay you some of this. I don't know that I owe you all of this. Now, are you entitled to funds that were in your trust account? Are you entitled to funds from the security deposit? The simple answer is yes, but the correct answer is that you're entitled to only the amount that's not in dispute. So talk to your client, get an agreement. At this point, you're probably going to want it in writing. You're just going to have to make sure it's clear. Find out how much the client is not disputing and get their agreement that you have earned that amount. So that was a more complex fact pattern. But was that the most complex fact pattern? Let me make it even harder for you. You reach out to the client. You look for that agreement as to how much is earned and how much is not in dispute, and you can't even get that agreement. They won't even agree to an amount. So you've got a client who acknowledges they owe something. You've got a written contract with them, but the amount is in dispute, and there's no part of the amount that's not in dispute. Now, what do you do with the security deposit that's sitting in your trust account? The answer is complex, but the answer is important. So note the answer well. It is incumbent upon you as the attorney to get that dispute adjudicated and resolved. Depending on what jurisdiction you're in, the name of this particular cause of action or the name of this particular lawsuit complaint may vary. This may be an action for declaratory judgment. This may be a quantum merit suit. This may be called something else. But it will always work in generally the same way. You as the lawyer have to start the proceedings. You as the lawyer have to leave the money in the trust account. You withdraw $0 and 0 cents during the pendency of this proceeding. And you go to the Tribunal of Competent Jurisdiction and you explain, you bring your client properly before this court's in personam jurisdiction through proper process, service of process, and you get the tribunal to adjudicate who gets what. Only after you have such an adjudication do you touch even a penny from that security deposit. Because until the amount is liquidated by the court or tribunal of competent jurisdiction, that money is not earned. The bottom line with trust account funds is this: the lawyer doesn't get to keep trust account funds until they are earned. Unearned funds stay in the trust account. When are they earned? They're earned when the client agrees they are earned, or the Tribunal of Competent Jurisdiction adjudicates them to be earned. Until then, they stay in the trust account. What if I move them to the operating account, but I don't spend them? No, moving them to the operating account was a violation. It's not the spending that is the violation. It is the moving that is the violation. And to help you comprehend why the moving is the violation, consider this. May God forbid any one of us lawyers ever get into such financial trouble that we have to declare bankruptcy. Or on the flip side, may God forbid that any one of us lawyers ever suffer an incapacity that would require us to be adjudicated to need a guardian. In either case, whether the filing of our own bankruptcy, either voluntarily or involuntarily, or the adjudication of incapacity, there will be someone else who's in charge of our accounts. If the unearned money is in a trust account, not the operating account, then that person who takes charge of our affairs, be it the bankruptcy trustee or the guardian appointed by the court because of incapacity, the person in charge of our affairs will be in charge of our operating account. But the money will be safe and secure in the trust account. Also, in both instances, whether it's a bankruptcy where the creditors are all coming knocking looking for payment, or it's a guardianship where perhaps because of the incapacity that preceded the appointment of the guardian, we, the lawyer, have fallen behind in our financial affairs. Either way, creditors are coming knocking. An adequate service of legal process can put a lien upon our operating account, at which point those unearned funds, if you'd put them there, would become the property of the creditor, of us. We can't let funds we haven't earned become the property of one of our creditors if we're not entitled to them. So that's part of the rationale as to why you're subject to discipline simply for moving the money out of trust and into operating when you hadn't earned it. With that said, this violation of improperly moving the money out of trust and operating because you haven't earned it, there are instances where that violation is curable, where you can remedy that violation. For example, you've sent the invoice, the client was behind on the bills, you called them up, they acknowledged the contract's valid, you did the work, they have a dispute with the amount, they want to pay you, they acknowledge you earned the money, they just don't have it, and you reach an agreement that they can use their security deposit funds to pay you. And with that agreement, you move the money out of trust and operating. And then, despite that agreement, now they decide they dispute your bill. What do? Well, you remedy the movement by putting it back. Take the money out of operating, put it back into trust, and then do what you got to do when trust account funds are in dispute. You start the proceedings to get the adjudication as to whether or not you've earned those funds. Now, as your friendly neighborhood bar grievance defense attorney, I got to admit, trust account violations or accusations of trust account violations, they're a dime a dozen. These accusations happen all the time. And why is that? Well, the IOTA account, as you set it up, it has to meet certain requirements. One of them, of course, is that the interest goes to neither you nor to your client, goes to the state bar for them to spend in the public interest. Another requirement is anytime the balance is negative in the trust account, the bank gives notice not just to you, but to the state bar. So anytime somebody bounces a check, writes an insufficient funds check from a trust account, nobody's got to report that violation to the bar because the bank's doing it for the lawyer. The bank is sending the bounce check notice, the insufficient funds notice, not only to you as the lawyer who holds the trust account, but also to the state bar. So the grievance, or at least the audit of the trust account, is automatic. The second reason why accusations of trust account violations are so frequent is that audit entitlement. Depending on what state you're in, state may or may not be allowed to audit the trust account for any old reason. Here in the state of Florida, there's a list of reasons that result in an entitlement by the Florida bar to audit a trust account. But as you might imagine, it's a rather broad list. It's some rather common occurrences. So imagine, if you will, that you, like I, are a friendly neighborhood bar grievance defense attorney. And the grievance you're facing is that the math adds up to a required balance of $10,000 and the account has only $4,000. Numbers are numbers, right? no matter how artfully I make the argument, I can't make 4,000 equal 10,000. 4,000 by definition is not 10,000. The numbers are against me, and that makes for a difficult defense and makes for an easy decision as to whether bar counsel, whether the prosecutor wants to bring ethics charges and try to subject the lawyer to discipline. So that's some of the issues you see when it comes to trust accounts. Now, whenever you receive funds or other property in which a client or a third person has an interest, that's got to be held in a trust account. And you got to promptly notify the client or the third person who has an interest in that. This is particularly true for clients whose cases are on a contingency. Especially when it comes to personal injury, there can be third parties who are neither you nor your client that have an interest in the recovery of that lawsuit. For example, if there's a personal injury, undoubtedly there's a physician. If there's a physician, undoubtedly there's a medical bill. And if there's a medical bill, undoubtedly there's someone looking to get that medical bill paid. Who are they going to turn to? One of the places they might turn is your client, who might pay it. That solves that lien, or might not be able to if they're horribly injured. There may be an insurance company, such as health insurance, who might pay the bill. But under the statutes of every jurisdiction I've ever seen, that insurance company now has a lien on the personal injury settlement for at least most, if not all, of what they paid for the medical that arose out of the personal injury settlement. Likewise, there are government responsibilities. We owe responsibilities to Medicare, Medicaid, sometimes SCHIP, and other government entities who might pay medical bills. Undoubtedly, there are statutes, such as the Medicare Medicaid Secondary Payer Act under the U.S. Code, where these government entities are entitled to reimbursement of past medical bills that were caused by the personal injury, and more often than not, are entitled to security for the future medical bills that they might see in the future that are fairly and justly related to this personal injury. For that reason, not only might you be reimbursing a past lien, you might have a responsibility to set up a set-aside account, like a Medicare set-aside account or Medicaid set-aside account or some other MSA, where you've got to put funds aside for the future under federal law. So whenever funds come into your possession, don't assume, well, part of it's my fee, part of it's my client's. No. There are a lot of others who may have a legal interest in that money. So when money comes into your possession that you haven't earned, you're putting in a trust account, not only because of the rules that regulate our profession, but for the practical purposes of these lien holders. Because if you were negligent with regard to the lien holders, then they're going to use that negligence to try to hold you responsible to pay the lien that should have been paid. So now you've got not only a problem of potentially being subject to discipline under your state rules, but also subject to financial liability under either statutory or common law or both theories of recovery. So the trust account is something that you may need to have depending upon the area that you are practicing. But there are other areas of law where you could conceivably avoid having a trust account. If you're practicing in an area of law where you never come into unearned funds and you never become the custodian of funds that belong to others or funds that others have liens upon, if you can rule out all those possibilities, then you can, if you wish, practice law without a trust account. If you're not in one of those types of practices, then my advice is to get help with the trust account. In my particular jurisdiction, Florida, for years, there have been rumors that they will create software that is available to members of the Florida bar that they can use that will automatically balance their trust accounts for them. For years, I've heard that this is in the works. But as I record this particular recording here in June 2020, so far that software is vaporware. That software is a myth, a legend. It doesn't exist yet. But there are vendors who sell software. My warning to you is this: even if you purchase vendor software that does a perfectly great job, you still have to have enough skills to run the software. Garbage in, garbage out is the cliche. If you put in the wrong data, you will get the wrong result. And trust account rules are very strict. In every jurisdiction, one of those strict requirements of a trust account is to reconcile the account on a regular basis. I think a regular basis would be at least monthly, and some jurisdictions specifically state at least once a month. I mean no disrespect to my fellow Americans when I say that technology has spoiled us, and in our personal lives, maybe we don't reconcile our bank account once a month like individuals always did in bygone years. There may be some of you within the sound of my voice that aren't even sure what I mean when I say reconcile the bank account. Here's what I mean. You pull up the monthly statement. You look at today's balance. You identify what checks are outstanding, meaning that they've been written by you to payment for others, but hadn't yet cleared the bank at the time of the bank statement. You also identify what deposits are outstanding, meaning you've made the deposit sometime between when the bank statement printed and today. And you have to take the bank statement balance, subtract the outstanding checks that haven't cleared yet, add the outstanding deposits that haven't cleared yet, and compare that to today's actual balance in order to reconcile the account. Is that something you do once a month, every month with your personal account? Maybe, maybe not, but it's something you do once a month, every month with your trust account, and you document that it was done. And you have that documentation ready to share with bar counsel if ever you are audited. But that's not the only documentation you will keep. You will consult and you will know the regulations in your jurisdiction for what other documentation you might have to have. Some of it can be a bit outdated and harder to gather after the fact because it's outdated. For example, in Florida, you have to have the deposit slip. And again, in our personal lives, we may take out our cell phones and click, and deposit the check. Or we may take the check and stick it in the ATM and deposit it. We're not filling out something called the deposit slip. But under the rules regulating the Florida bar, not only do I have to fill it out, I have to keep a copy of it. So I have to go deposit trust account checks in a different way. Because if I just stick it in the ATM or zap with my app on my iPhone, I'm not going to have the requisite deposit slip. So depending on what jurisdiction you may be in, the trust accounting rules might be outdated. They may be cumbersome, but they're still required. And it becomes a technical violation if you don't follow them. They audit the trust account. You're supposed to have 20 deposit slips. You've only got 18. It's a violation. They audit the trust account. You're supposed to, perhaps in a particular jurisdiction, reconcile the account once a month, and you've got 10 reconciles for the calendar year, not 12. It's a violation. So get some help, but don't abdicate these tasks. Delegate these tasks. When you delegate, someone else does them, but you make sure it's done right. When you abdicate, you wash your hands of it. Don't do that, because the rules regulating our profession don't allow you to wash your hands of it. If whoever you delegated it to didn't do it right, you can be held responsible. So these are some important issues when it comes to trust accounts. And those issues and more are found under Model Rule 1.15. And as lengthy and detailed as Model Rule 1.15 is, any state rule that adopts it is even more lengthy and detailed. So consult and know and revisit and keep up on that particular rule if you've chosen an area of practice where trust accounts are unavoidable. As an officer of the court, we owe our clients and third parties nothing less than full compliance with what are essentially accounting rules, not legal practice rules. Most lawyers don't have an accounting background, but that's not a defense to even a technical violation of Model Rule 1.15 or the state rule equivalent. So know what you need to know about accounting to keep a trustworthy trust account. That brings us now to Rule 3.5, another requirement that we have as officers of the court, another duty we owe to the judicial system, and that is about impartiality and decorum of a tribunal. Here, it's a violation of the rule if we try to influence a judge, influence a juror, or even influence a prospective juror or other official by means that are prohibited by law. Another way that we might violate Model Rule 3.5 is through an ex parte communication. That's a Latin phrase, ex parte. What does it mean? It means having a communication with the presiding judge or legal officer. And if you're not in a court of law, it may be a hearing officer. If you're for an agency, it may be an agency head, but any kind of adversarial proceeding. If you're one-on-one with the decision maker and your opposing counsel is not there, that is an ex parte proceeding. There are statutes and rules that allow for certain ex parte proceedings because certain proceedings proceed ex parte. For example, filing a will with a court of law after the passing of the person who filled out the will. That's done ex parte because the statute permits it. Likewise, rules of court might allow for certain ex parte hearings. Now, whatever it is you're doing ex parte, you can't do it ex parte if there isn't a statute or a rule allowing you to do it ex parte. If there is a statute or a rule explicitly allowing ex parte, then you may proceed ex parte. But now you have a higher duty of candor to the tribunal. It's not quite a duty of impartiality when you are in an ex parte proceeding, but that might be a reasonable analogy insofar as you have to raise all sides of the issue when you're in an ex parte proceeding. When you're in an adversarial proceeding, it's your job to raise accurate statements of the law, even if the law may be adverse, and it's your job to raise those favorable facts and to present them in a non-frivolous and permissible light that is most favorable to your client. That describes your role in an adversary proceeding. Your role in an ex parte proceeding as an officer of the court is different because you've got to bring the facts, good and bad, as well as the law, good and bad, to the attention of the judge. That's an ethical requirement of attending an ex parte proceeding. But make no mistake, you may not have an ex parte proceeding unless there is a statute or rule allowing ex parte. Unless that statute or rule says in that instance for that thing or transaction or matter, you may go ex parte. Unless it says so, then the very act of proceeding ex parte is a violation of Rule 3.5. Ex parte communications are a violation of Rule 3.5 unless explicitly permitted. And what do I mean by that? Well, say you're in an adversarial proceeding and you speak one-on-one with the judge about something relevant to that proceeding. That is an ex parte communication. That is a violation by you. It's also a violation of the Code of Judicial Conduct. So it's a violation by you and the judge. If it happens inadvertently, it can be remedied. You make sure that no decisions are made and nothing of binding or lasting effect occurs, and you immediately get opposing counsel involved as soon as practical, and you redo the proceeding. You redo the communication. You remedy it by making the prior null and void, getting your opposing counsel in front of the tribunal, and making sure your opposing counsel is heard. But that's how you remedy a violation that's already happened. You're better off just not violating it to begin with. So you can be subject to discipline for having an ex parte unless there's a rule or statute permitting it. If you engage in conduct that is disruptive to a tribunal, you have violated Rule 3.5. You might give an impassioned speech. You might drive home how important this is, Your Honor, to my client and to society, that we have a verdict in my client's favor. Impassioned speech at an appropriate time where it's your turn to speak. That's not what I'm talking about. I'm talking about disrupting the tribunal. So causing a riot, throwing something at your opposing counsel, assaulting the judge. These are obvious violations. Some less than obvious violations. What about just some trickery? You see the jury is enamored by your technology. So when the opposing counsel's critical witness is on the stand, you make sure to fiddle with your technology, try to divert the attention of the decision-making jury. That would be a violation of Rule 3.5. There's an old saying, who knows if it's true, an attorney who used to like to smoke a cigar during trial. I can't imagine this was ever allowed anywhere, and allegedly the attorney put a metal rod through the cigar so that the ashes would get extraordinarily long without falling off, and the attorney's goal was to distract the jury, who instead of listening to opposing counsel's evidence was staring to see when will those ashes fall. I don't know if that was ever true, but whether or not it was true, that would certainly be a hypothetical description of a clear violation of Model Rule 3.5. So artifice has its place, acting has its place, dramatic presentations and movements of props have their place, but we can't cross the line and engage in conduct that's intended to disrupt the trial or the courtroom or the proceedings or the tribunal, because that becomes a violation of Rule 3.5. And I would be remiss not to end my discussion with the theme of officer of the court without returning to Rule 8.4. I know that we've visited it before, but it certainly is applicable here, so I'd be remiss not to point it out. When is it professional misconduct under Rule 8.4 that we could put under the theme violation of our duty as officer of the court? Well, acts that reflect adversely on our honesty, dishonest acts. When we are in court and we are making statements, we are officers of the court. Now, witnesses have an obligation of truthfulness during a proceeding or during a trial or during a hearing. That kind of gets turned on again and turned off again, on again, off again. And they know, these witnesses know when it's on and when it's off. You've been in a courtroom, you've seen it, or you've watched courtrooms on TV, you've seen it. They take the stand. In the olden days, they put their hand on the Bible, not so much anymore. In the olden days, they swear. Nowadays, they swear or affirm. I swear or affirm, tell the truth, the whole truth, and nothing but the truth. So help me God. I do. So they know it's been turned on, their obligation not to perjure themselves. But we lawyers, as officers of the court, it doesn't get turned off. When we're before the presiding officer, when we're before the justice, before the judge, before the hearing officer, before the tribunal, before the agency head who's holding an evidentiary hearing, at all times that we are speaking, we are telling the truth, the whole truth, nothing but the truth. Not necessarily under penalties of perjury, but certainly under penalty of violation of the model rules of professional conduct, such as Model Rule 8.4. When we answer a question from a judge, we got to tell a judge the truth, the whole truth, nothing but the truth. Otherwise, we're violating our rules of professionalism, such as Rule 8.4. Now, McGinley, what if a judge is asking me a question that's improper? Judges are human. They can ask an improper question. Well, if that happens, instead of answering the question, explain politely, respectfully, as an officer of the court, that you believe the question may be improper and why you believe it may be improper, and ask permission not to answer. Ultimately, if you're ordered to answer, maybe even then you'd ask that the order be held in abeyance so that you can seek appellate review. If you can't, and you must answer, then you must tell the truth, the whole truth, and nothing but the truth as an officer of the court. What's that also mean? Well, sometimes you're making an argument in court, and you have to, in good faith, be arguing what you understand to be the truth, a truthful summary, a fair summary, a non-frivolous summary of the evidence, such as when you're making an opening statement or a closing argument. So when you're in court and you're not the lawyer, you're a witness. I do. Your obligation to tell the truth, the whole truth, and nothing but the truth gets turned on and turned off, but not for the lawyer. It's on at all times. Does that mean we can't be zealous advocates? No, that's not what it means. It's still an adversarial proceeding. You can still make an argument for a good faith modification, reversal, or change in existing law after acknowledging what the existing law is. There may be times where, in order to have standing to challenge a law, someone has to violate that law and make that violation as a good faith effort to change, challenge, modify an existing law. So you can be involved in such a good faith effort, but it has to be in good faith and it has to be for that purpose. We are officers of the court. So when we speak in court, the words we speak are words upon which the court may rely. And with that noted, we've covered Model Rule 1.11, Model Rule 1.15, Model Rule 3.5, and again, Model Rule 8.4, under the theme of officers of the court. An important theme, because you and I are part of the justice system. You and I, as lawyers, are part of reaching truth and justice and securing justice for our clients. It's an important job, not one to be taken lightly, and it makes our rules of professionalism noble rules indeed. With that said, thanks for joining me. I'll see you soon for another lesson, and until then, may God continue to bless us all. Thank you and good night.